All right, everyone, good evening and welcome to the podcast for tonight, which is North Carolina's Access to Justice Crisis with our special guest judge, Richard Dietz, presented to you by the North Carolina Justice for All Project. You can welcome me, your facilitator. My name is Yazmeen Gadalla. I am a North Carolina certified paralegal, and I am a bankruptcy paralegal at Hendren, Redwine, and Malone. And in my spare time, I am the North Carolina Bar Association Paralegal Division's chair. So I'm going to take a moment to allow our JFAP team, as we know the Justice for All Project to be shortened down to introduce themselves with a brief 1 or 2 sentences as to who they are and what they do. And we will go ahead and take it from the top.
Thank you, Yazmeen. I am SM Kernodle-Hodges. I am a legal project manager with Tolliver, Richardson & Kernodle. I am one of the co-founders of the North Carolina Justice for All Project.
My name is Alicia Mitchell-Mercer. I'm a certified legal project manager with Lex Project Management Consulting Group and a FINRA securities arbitrator, and I'm co-founder of the North Carolina Justice for All Project.
My name is Rachel Royal, and I am a freelance paralegal with Royal Touch Legal and Business Solutions, and I'm in Wilmington, and I am a contributor to the Justice for All Project.
Hey, I'm Morag Black, and I am a charter member of JFAP, and I'm a personal injury paralegal with McGraw Law.
Good evening. I am Shawana Almendarez. I am a North Carolina certified paralegal, and I am the owner of North Carolina Paralegal Consulting Service in Kannapolis, North Carolina, and also a JFAP team member.
Okay. Now that we know who our JFAP team is, I want to give a little background as to the purpose of our podcast for this evening, which is one, to explain who we are, as we've already kind of touched base on our individuals, what we're trying to accomplish, and the initiatives that we support, and how to educate people on the Access to Justice initiatives that we are supporting today. In this podcast, we're going to cover some frequently asked questions that we have come across. We're going to talk about the Access to Justice dilemma, national and statewide legal regulatory reform, and how JFAP proposes to help bridge that access to justice gap with paraprofessionals. So that being said, I'd like to introduce our very special guest, the Honorable Richard Dietz. So I would like to give a little background from him, or him, excuse me. Judge Dietz comes from a mountain family of railroad and telephone workers. From an early age, his parents encouraged him to study hard and get an education. He succeeded, becoming the first in his family to attend college. He went on to graduate first in his class from Wake Forest University School of Law, and later earned a master's degree from Duke University School of Law. As a lawyer, Judge Dietz has become one of the most accomplished appellate advocates in North Carolina. He has personally argued in the U.S. Supreme Court, only something a handful of lawyers in the state has ever done, and is a board-certified specialist in appellate practice. Before joining the Court of Appeals, Judge Dietz was a partner at Kilpatrick, Townsend & Stockton, LP, a 650-lawyer international law firm with its roots in North Carolina. He also served as a law clerk for 2 highly regarded federal judges, Judge Emery Widener on the U.S. Court of Appeals for the First Circuit, and Judge Samuel Wilson on the U.S. District Court in Virginia. Judge Dietz joined the Court of Appeals in 2014 and is now the 3rd most senior judge on the 15-member court. He has distinguished himself on the court by writing thoughtful opinions that are concise and easy for the public to read and understand. Judge Dietz is happily married to Kelly Dietz, who is both the love of his life and his most trusted advisor. Kelly is a former Capitol Hill staffer and political appointee who now works in higher education. So welcome to you, Judge Dietz. I am going to let you lead off our questions for this evening with what is probably the best question to start with. What is the access to justice gap, and why is it such an important topic to bring us here this evening?
Sure. So thank you all so much for bringing me on this podcast. So I got to know the Justice for All Project and the folks that are here tonight several years ago. I was just really inspired by the work that you all are doing, and have reached out a number of times and said, how can I help? And I think this question is the main reason. So I serve on the Equal Access to Justice Commission. This is a passion of mine, this access to justice gap. And I'll tell you a little bit of the personal story of why. This isn't something I shared much, but I gave the commencement address to the law students at Wake Forest last year, and I decided to share it with them because it was a message about why law school, and in particular Wake Forest Law School, where I graduated, was so important to me. As you heard there, and thank you, I think you must have taken that from my website. That was a braggy introduction that you gave for me, but that I think I put on my website. But thank you for reading that. It's one of the things you have to do as judges, talk about your resume. But one of the things I don't share there, but is that I was from a pretty poor family. So when early in law school, my mom got sick with cancer, and she passed away at a very young age. So she was young even when I was born. So it was just barely over 40 years old. And it was very hard on me and my family. We didn't have health insurance. And my mom, who's in Pennsylvania, and I was, down in law school in North Carolina, she was struggling to navigate the Medicaid system. And I really wanted to help, but we didn't know any lawyers. And it was hard for me in particular because I was in law school, but still knew no lawyers that could help her in Pennsylvania. And it really helped me see how hard it can be for people to get legal help. I think as I go around the state, which I do all the time, and talk to ordinary people about, what is your view of the court system and the justice system and that sort of thing, what I hear more often than any other comment is, why is it so expensive? I've needed a lawyer at some point, and it was too much money. And so that, to me, is the core of the access to justice gap, is that there are people who need legal help and they can't get it. And there are, of course, people, very low income people, that qualify for things like the legal aid programs that we have here in North Carolina. But the justice gap is much wider than just people at the very bottom of the income brackets. It is ordinary North Carolinians who just have other priorities they need to spend their money on, and are unable to find the funds they need to pay for legal counsel. And that's what's inspired me about you all, is that I think you have a solution to that problem that we desperately need, because I don't want people to experience what I experienced in my life, and what I think so many other North Carolinians experience every day, which is just the desire to have someone as an advocate to help them navigate the legal system, and being unable to get that help because they just can't pay for it.
Thank you, Judge Dietz. That was a very insightful look into it. Moving the conversation along just a little further, I would like to ask the question that you are all free to answer. What are some misconceptions about the access to justice gap?
This is Alicia. I'll take that question. So from the public's perspective, I think many don't realize that they don't have a right to counsel, and when they're having a civil problem. And so they just don't know that it's going to be an issue until they reach out for that help. If they find themselves in the middle of an eviction or a family law case, they might assume that it's easy to find someone to help them. And so as an example of that, I remember back in 2015, I had a father of three reach out to me. He had three girls. They were 12, 10, and 8 at the time. And he had just gone through a divorce. The mother was having some problems related to drugs, and she had taken off with their three children. She went to another state. And what we found out was that there was a felon who had been released from prison, and she had taken the children and she went to another state with him. And so the father was contacting me at this point, asking me what to do. By the time he had contacted me, he'd already called the police. They told him to file something in court. He'd already talked to legal aid, and they said that they couldn't help him because it wasn't like a domestic violence case or anything that they could take on. So, he reached out to a couple of attorneys at this point, and it just, the retainers that they wanted, even the hourly fee that they were charging was just too much for him. So by the time he contacted me, it was kind of like, I have nowhere else to turn. And I had to tell him that I couldn't help him, even though I had been, working in family law for almost 15 years. I knew what to file, but there wasn't really anything that I could do. So the only thing that I did know to do was to go around and beg every attorney that I knew to let me ghostwrite this for him and then just review it, just supervise me, please let me help this person. So I did find an attorney who actually wasn't even practicing a whole lot in family law at that time. He kind of dabbled if his clients needed him to do it, but he agreed to go ahead and supervise my work. I did all the workup. I contacted the other state. I got in touch with the man's parole officer because he had just been released on parole to get all that background information attached to the complaint, and we got it filed. And we did get an order for him. We had to go through a lot, just going to the other state to try and get law enforcement involved, to try and get DSS involved, to try and figure out where the kids were so they could go pick the kids up. And one of the things that stuck with me, he did get his kids back. Now, it took almost 3 weeks from the time we got the order to try and track them down and get the kids back. And, we were very lucky in that situation. But when they picked the children up, one of the girls had been assaulted. Another, they had, two of them had, scabies. There was a lot going on, and they had found them at, what I guess they would call a heroin house or something like that. So what really struck me was, this was a single father working in a managerial position at a fast food restaurant. He loved his girls. He was a good father, but he just didn't have the money to get any help. And so I thought to myself, what would have happened to him if he wouldn't have had anybody to advocate for him? Who could he have turned to if I, wouldn't have had resources, right? And so that's one of the reasons that we think that this access to justice gap is so important, because he could cover bills, but when it came to a crisis, he didn't have the money for a crisis. So I think, additionally, that was a kind of serious situation, but, whether we're talking about evictions or a myriad of other issues, we already know that 92% of Americans who have a civil legal problem aren't getting any help. I mean, the Legal Services Corporation tells us that. And it's nearly impossible to navigate the court system on your own if you don't have legal training or legal knowledge, especially just trying to figure out what laws apply to your case. And if there are local rules or local forms that you have to fill out, just navigating all of that is too much for the average person.
I think you raise a lot of great points there, especially in regards to the thing that I think people always forget is, or just don't know, is you really don't have a right to counsel unless it's in a criminal case, and even then it's very bare bones. So I agree with you that there needs to be that kind of access to those folks who just have every other ability except the ability to pay. All right, so going on to our next question that, we've been doing such a great job with addressing all these questions that are coming up. Here's another one. What do you mean when you talk about civil legal needs? How do individual needs show up as a legal crisis in just the daily way?
That's a great question. I'll take that one, Yazmeen. When we talk about civil legal needs, we've done research to cover our state, but as a whole, all of the reports and the data we've collected has led us to utilize the Legal Services Corporation report overall. And they indicate that civil legal needs are those that typically involve basic everyday living, healthcare, housing, education, a person's ability to generate their income, or public safety. Particularly after a natural disaster, hurricanes, tornadoes, we've all experienced Hurricane Matthew and Florence, and most recently, Puerto Rico has experienced another hurricane that has left this particular island desolate. We have issues with water, shelter, and food. When you talk about water, we thought Flint, Michigan was going to be our only crisis and our only issue. But now we know that in Mississippi, they're also experiencing issues with water. And that's just an everyday thing that we take for granted that we're going to have access to. People often don't realize that they have a legal need until something takes place. I hate to say a crisis, I'm going to say something that stretches them beyond their bandwidth, to say the least. COVID changed the perspective on what needs are, because it balanced the playing field in a way that those who are normally not impacted impacted financially were, because they couldn't go to work and we were all at home experiencing the ins and outs of that particular pandemic. Others experience medical hardships in a way that when they reach out for medical care and assistance, not understanding medical language and what those forms actually are supposed to entail, are also other things that citizens experience when they're considered meeting civil legal needs or meeting the threshold of having civil legal needs met. One of the things that I stress a lot is housing. At the end of August, I think the last count for housing was 8.5 million people were behind on their rent. And it has been predicted by the US Census Bureau that in November, 3.8 million citizens will be evicted because there is no other way to keep them in their homes because they don't have the income and the resources. The rent rates have skyrocketed. A lot of families are still reeling from COVID and the impact that it's had on them. And those things alone, and not having those protections in place that we once had with the moratoriums, will create a different bubble of civil legal needs for us.
And I definitely see what you've been saying, especially when you think about people who worked in the entertainment industry who almost overnight lost their jobs, their source of income, because who's going to the movies during COVID? And then rent, at least in our general area, I've seen people talk about their rent from last year has gone up 25% in a single year, and it used to be affordable, and all of a sudden now you have a 25% jump and you just can't afford it. So it's not a slight on the person, it's just a circumstance that you don't expect.
I agree.
And I can
So
kind of
another
piggyback
question.
on that. Sorry, I can kind of piggyback on that. I recently worked on the Housing Stability Project with the North Carolina Office of Resiliency and Recovery, which was a partnership with the North Carolina Bar Association and, Bar Foundation and Pro Bono Resource Center. And one of the things that we found throughout that was, even though the HOPE program was a state and, a federal program, and then there were also different counties that had their own initiatives, we were just finding that landlords didn't want to participate. So even though the federal government said that they were eligible for this program, if the landlord didn't agree to it, then that person still could legally get evicted if they didn't agree.
Thank you for the piggyback, Rachel. I think that's also important to note, that it's not just as one-sided as sometimes you would kind of wish it would be. You would think that we could have a nice place where everyone works together, but sometimes it just does not work out that way. So our next question that we have this evening is, what barriers do you see that interfere with North Carolinians having their legal needs met, their civil legal needs met, excuse me?
So I can take that one. This is Rachel. So obviously we know that finances are one of the biggest issues. Some people can afford to, they can pay for legal services, but it's not without having to give up some other essential bill or, just scraping everything out of their savings, which shouldn't be what we have to do in order to afford legal counsel when we need it. And, obviously there's an education issue, because 20% of the United States doesn't have essential education. They are considered functionally illiterate. And in North Carolina, that number is around 13.4%. So 1.5 million of the people in North Carolina are considered functionally illiterate. So if you're thinking about, we're people who are in the legal field who've been educated and work in it, they know how many forms and rules and statutes and all of those things. It's really difficult for people who do know how to read and write well to have the time to research those things to represent themselves. And people who do not have that education are just not able to do that. So that's a huge barrier. Obviously the ability to drive and to get to your court date, that's also a huge issue. And in North Carolina, are millions of people who are without a driver's license because, it starts out with getting one, failure to pay a tag or a seatbelt violation, and then those fees and fines just keep racking up until they're not able to pay. And so that's another issue. As Kernodle already mentioned, disaster is a huge issue, especially in North Carolina. We've dealt with a lot of hurricanes. I live in Wilmington, where Hurricane Florence was a huge issue in 2018. And there were a lot of people who were just completely out of their homes for even up to 2 or 3 years because they couldn't get insurance companies to pay for their claims. They were denied for FEMA, and they didn't have any other way to get their houses fixed. So a lot of people were living with other people, living out of hotels. There was a big problem with contractors taking money for things and then never doing the work. So that is another thing. And then just their inability to determine that their issue has a legal component. They may know, let's say they even have a court case. Like I have a friend who several years ago, she had a custody case where she had gotten custody of her children and her ex-husband had moved out of state. And then when she ended up moving out of state, she didn't realize that he had filed for custody back in North Carolina, where she had the custody case. He knew what her address was, but because she didn't know that she needed to change that address on file with the court, he purposely sent it just to the address with the court instead of the address that he knew she lived at. So she ended up missing a court date and ultimately ended up losing her kids because it made it look to the court like she was not paying attention to what was going on with her case, and that she was, when she ended up going to court, actually went to the hearing with her because she just wanted somebody there with her. She did have an attorney that she had paid a nominal fee just to represent her at this hearing, but because he hadn't, really developed her case the whole time, he didn't really represent her in a way that an attorney would have if she had been able to pay him a full retainer and the full, hours and all of that. So there wasn't really a whole lot that he was able to do to keep her kids. So just little things like that, that, people are not aware of to do with the court system. It would really help if they had someone that they could go to and pay, $50 an hour or whatever the fee is to be able to talk with somebody and get that information up front.
Great, thanks, Rachel. Yeah, obviously, I think we can all agree that fighting these barriers to accessing civil legal needs is a very important thing, and some of them you just don't think about. Like a lot of people don't think about people who don't have the ability to drive. All right, so there are some services that are already out there to assist, but not in all of the ways. But I want to expand a little more on Legal Service Corporation. So if someone can answer, what is Legal Service Corporation and what part does it play in the access to justice discussion? I would appreciate it.
Yes, Yazmeen, this is Shawana. I can answer that. Our team members have spoken on the Legal Service Corporation a couple of times because we've used some of the studies that the corporation has conducted in the proposal. But the Legal Service Corporation was created by the LSC Act in 1974. In 1974, our Congress found that there is a need to provide equal access to justice in this nation, and that there is also a need to provide high quality legal assistance for those who can otherwise afford legal or adequate legal counsel. And so the mission of the Legal Service Corporation is to provide, they are a nonprofit organization that provides grants for high quality legal services in the civil legal needs area, as well as they promote equal access to justice. They distribute more than 90% of their total funding to 132 independent nonprofit legal aid programs across the United States.
Great, and thank you for mentioning legal aid, because that is my next question. What is the income eligibility for legal aid? How does that compare from North Carolina to other states?
Well, I can answer that one, Yazmeen. This is Morag. Everybody is pretty much aware that there is a cap on income for legal aid services. Out of, I don't know, the half a dozen people that I asked who all work in the legal profession, none of them could tell me what that was. And that's a problem. You know, for a family of 4, your income cap is $33,125 a year. For a single person, that's $16,100 a year. And that's really not a whole lot. That is basically one person making roughly $16 an hour to support a family of 4, or 2 people making roughly $8 an hour, working full time. That's really not a lot. Unfortunately, what people also are unaware of is that that cap doesn't change from state to state. That cap is nationwide. Now, your $8 an hour goes a whole lot further in Mississippi, for example, or Onslow County, North Carolina, where I'm at, than it does in New York City, Manhattan, anywhere like that. So it's not reasonable to tether legal aid eligibility to a specific number rather than to a cost of living. It's unfair to those who live in a higher cost of living area, but it's also unfair to those living in a lower cost of living area, because typically they don't have the same number of attorneys that are available in your higher population densities.
And I think that you kind of touched on this, which goes into my next question, because you mentioned the cost of living in Onslow County. And so my next question is, how does North Carolina compare when it comes to income, cost of living, and other demographics important to the access to justice discussion?
This is Alicia. I can answer that question. So Rachel already touched on the fact that in North Carolina, we have a 13.6% of adults who are functionally illiterate, and she explained kind of the repercussions of that, having some trouble advocating for yourself in the legal space and otherwise when you are having trouble reading and writing beyond a basic level. But in addition to that, we have the basic income, or the median income, being $56,642 as of 2020. And I recently had a couple of family members move out of the state of North Carolina just because they found it too expensive to live here any further, specifically in Charlotte, when the rental rates have continued to increase year after year. And the average rent in North Carolina, from what I understand the last time we checked, was about $1,300 for a family of 4. And so if you think about it, that's almost 30% of their income. And typically, even if you're, say, making $55,000 a year, a lot of people aren't, what's left is going to go to things that you need. So it's going to go to food and utilities and childcare, medical care, and other things that you need just to survive and to live. So that means, as Judge Dietz talked about in the very beginning, that there's a huge portion of the middle class that are still in the access to justice gap, because although they may make enough to be able to cover their basic needs, if something happens out of the ordinary in the civil legal realm, they are not prepared to cover those expenses. And then another issue is the internet. So we have 1.1 million North Carolina households that lack access to high-speed internet. And I think that the first time this really became well known to me is when COVID started, right? And the schools shut down. A lot of churches and community centers started to open in order to be able to offer those services to families that didn't have access to computers and internet. So we saw kind of that disparity when COVID showed us that it was there. So I think that, you know, for those families, for the 1.1 million North Carolinians, if they don't have access to the internet, they probably don't have access to a computer. They probably can't, you know, print the things that they need to print, be able to put the legal documents together in order to be able to file anything if they needed to file anything. And so that kind of takes me to another thing. We have this great resource that the AOC and I think the Equal Access to Justice Commission as well put together, which is the Guide and File. And we know that Guide and File is a free service that you can get on there, and you can take these kind of interviews and it'll walk you through the process of filing your documents. But if you take those interviews, if you run into any questions about what is applicable to your particular case, or if the documents that Guide and File can generate doesn't fit the substance of your case, then it's going to recommend that you go to a lawyer, which if you're using Guide and File, you probably can't afford anyway. So, you know, those are things that are part of the access to justice issues from a demographic standpoint. And then most recently, we've been talking a little bit about legal deserts. So this North Carolina State Bar is studying legal deserts right now. And we know, I think that 48 of our 100 counties is a legal desert. And what that means is that there is less than one attorney for every 1,000 residents in a particular county. And we have 10 counties where the number of lawyers available are in the single digits. So you can imagine if you're in those counties or if you're in a rural area, that if you need access to an attorney, that can be an impediment or a barrier to getting that help.
Yeah, when you consider 10% of the counties just having single digits, I mean, that is, even if you can find an attorney that you could afford, he probably has another 1,000 just like you that he's trying to support on his lonesome.
Right. And so, you know, most of the attorney population is concentrated in the Research Triangle and Mecklenburg County. It's a lot more sparse once you leave the major metropolitan areas.
Yeah, and it makes it hard too when you consider small counties. I mean, every North Carolina county does things just a teensy bit differently, not usually too much, but it's always something to keep in the back of your mind too when you're looking for someone. Can this Wake County lawyer help me in Onslow County? And vice versa.
Right.
So talking about funding for these legal aid services, because we've talked about how much that they're needed, but what kind of money goes towards them? So how much funding does legal aid receive, and has that changed since COVID?
I'll take that. This is Kernodle. Really, if you look even on the chart that's provided, you'll see from 2017 to 2020, there's not much of a change. It's roughly $1 million change for each year. And it stops at 2020 because there has been no update and no change. Largely, the funding that Legal Aid of North Carolina receives on an annual basis comes from the Legal Services Corporation. I'm going to use the word supplemental funding comes from the state bar or state court fees, things like that, grants and other private donors. Rachel Royal does a lot with legal aid. And when she shared with me that that was the only way that legal aid could be funded, it's not a shock to me why they often turn families away who need their services. They're not even getting a budget that grows on an annual basis that meets the need of the growth of our state. If you look at the state's population, last count, we had 68 families moving to North Carolina, they said a day, right? Coming into our state, starting new jobs, wanting to find reasonable housing, trying to educate their children, place them in schools where they're going to be safe, where they're going to have access to resources to better themselves. And every now and then, they may have a problem that they need a legal aid program to aid and assist them in. Either they're not going to have their needs met because they don't meet the income threshold or guideline. Legal aid doesn't have the funding or the staff for those issues. And all of those things can create issues for those who need those legal aid services. And it's another reason why legal aid should have additional funding, and if not funding, have a limited license, a licensing technician, a court navigation program, or some of these other regulatory reform innovations that we've talked about to aid and assist them. So while they're trying to figure out how to get more funding, we can offer the services that are needed to fill that gap.
That's great. I mean, obviously that's our goal, is to fill that gap and get people the access to justice that they need. So in trying to get that, can we talk about a little about the 2021 North Carolina Civil Legal Needs Assessment?
Sure, this is Rachel. I'll take that. So in 2021, the North Carolina Equal Justice Alliance partnered with the North Carolina Equal Access to Justice Commission and UNC Greensboro, and they had the idea of doing this civil legal needs assessment because one had not been undertaken in our state in over 20 years. So it was definitely something that was needed to kind of give state providers a little bit more of an idea of what the population is really going through to try to get legal assistance. Some of the stats that they found were that over 2 million people in North Carolina are eligible for legal aid, and that 71% of low-income families are going to experience at least one civil legal problem in a year. And then of that 71%, 86% of those needs will go unmet because of limited resources for our state's legal providers. And we know, obviously, from the national LSC stats that could have even gone up since then. And we also need to remember that although this came out in 2021, most of the data that went into this report didn't take into account all of the issues with COVID. So I think they were kind of wrapping up as COVID really was ramping up. So that is really something we know, that these issues have gotten even worse, especially when it comes to housing issues, and other things that got even worse during the pandemic are things such as domestic violence, human trafficking, all of those kinds of things. The report also found that there was one legal aid attorney for every 8,000 North Carolinians who are eligible for legal services. And I think there was actually a report that came out recently where legal aid said that they have 255 lawyers. And that's really for about 1.4 million people in North Carolina who are eligible for those services. So those numbers just don't match up. You can't have that few number of lawyers who are representing that many people. And by contrast, there's one private lawyer for every 367 North Carolina residents. But as Alicia just talked about with the legal deserts, those are not necessarily spread out across the state. A lot of them are, kind of concentrated in the bigger counties like Wake County and Mecklenburg County. So that's where a large number of the lawyers are. And I want to ask Judge Dietz if he has any thoughts about the civil legal needs assessment, since he's a commission member. I believe he was a little bit involved in that. So do you have anything on that, Judge Dietz?
I don't have much to add. I think when I reviewed the report, I think what struck me is the idea that most low-income families, and I think this is because most families in North Carolina will have a legal problem that they need help with, every year. And when you see the numbers of how many lawyers are available to meet those needs, you realize that it's not something that will be fixed by trying to hire some more legal aid attorneys. We need a much bigger solution because the need is so great. We just don't have the resources to ever provide a solution. It's part of why I'm excited, to hear more from you all tonight, is I think there are other solutions to the problem, and we're going to look for them.
That's great. Thank you, Rachel. Thank you, Judge Dietz. So in talking about the legal needs that are out there, what are the areas of legal needs that are greatest compared to what legal aid can actually cover? I mean, we've discussed that there are only so many attorneys that practice in legal aid, but I think maybe we can elaborate more as to what it is that they practice versus what's actually needed.
Okay, Yazmeen, this is Shawana. I think I can speak to that one. According to the North Carolina Civil Legal Needs Assessment, it indicated that the top 10 areas that have the highest civil legal need are summary ejectment, domestic violence, custody, collection on accounts, permanent civil no contact orders, divorce, foreclosure, finding an order of foreclosure, incompetency and guardianship. And I would like to mention that although the legal aid of North Carolina does provide summary ejectment assistance, domestic violence assistance, as well as assistance with custody when it's connected with domestic violence, as Alicia had said earlier, they don't provide any assistance with the latter part, the divorce, the foreclosures, and competencies, and guardianship. And so there's still a need to fill the gap in those areas of law, and paralegals and law students can directly help with that.
Great, thank you. I appreciate you elaborating a little more as to what the legal needs are. And if you see the slide here, you can also see kind of the what's offered, what's not in nice greens, yellows, and reds. So moving on, why is increasing pro bono not the answer to mitigating the access to justice gap? I mean, we've talked about it being necessary, and pro bono, obviously, attorneys provide their services reduced or for free, but why is that not the solution?
Well, I can take that one too. You know, if only pro bono were the answer, right? I think in my 20 plus years of being a paralegal, I have only heard one attorney tell me, oh yeah, I took this case on as pro bono. And that was today. So that's a problem. You know, a lot of attorneys, I mean, let's face it, a lot of us don't like to work for reduced wages, right? The work we do is a valuable thing. And if we have a set rate, then we kind of like to get that rate. But pro bono is also a fabulous way to give back to your community. Unfortunately, as the slide says, of all of the 1.3 million licensed lawyers, not just those in active practice, but everybody who is semi-retired, retired, judges, you know, if they were to handle all of the need, each of them would have to put in 180 pro bono hours. That is approximately a month and a half of working full-time, doing nothing but pro bono. That's really hard to do. You know, maybe you could take one or two cases. Maybe you could spend a whole week volunteering as a legal aid attorney, but you can't spend, you know, a month or 2 months and not get paid for it. The average number of pro bono hours provided by the roughly 50% of lawyers who provide that is about 55 hours in a year. That's crazy. It's just half of our 1.3 million attorneys who are doing less than a third of the hours necessary. That's why pro bono can't fill the gap. We just don't have enough people.
And I think you make a good point. People like to value their time, and especially attorneys. And at least in North Carolina, I know that there is a, you know, best intentions, you should try and do 50 pro bono hours. but I believe that I've seen the common experience being kind of like you mentioned, I take one pro bono case a year, something of that nature, but I'll go to a pro bono event and help, but that's not what the need is here. It is a case-by-case basis.
Yeah, and Yazmeen, you make a good point there that it's not really actual cases most of the time that's being taken. I know that there are attorneys who do that, and that's, you know, absolutely needed and wonderful. But most pro bono projects are centered around brief advice and counsel. That is great for helping people who are representing themselves, but it's not going to help them when they actually have to go into the courtroom and then they don't know what the next step to take is.
Yeah, they just know this is the next step, but the step after that, no idea. All right, so going on, we're going to go ahead now and talk a little bit about regulatory reform background. By a little bit, I mean a lot. So I am going to ask this next question, which is, what is limited licensing?
Okay, I'll take that one because I tend to love the comparison between the nurse practitioners and the paralegals and lawyers. In short, limited license, you would consider it so as a reform of that authorizes non-attorneys who meet certain educational requirements, employment requirements in terms of their experience, I should say experience requirements. And they will take that education and that experience to advise clients in specific areas. So if you were to have a limited license, it will be catered specifically to that area of specialty. So that's kind of like the nurse practitioners. They can do a lot of things, but they can't do everything that a doctor can do. So a limited licensee would aid attorneys in that same capacity.
Okay, so now we're really getting into the meat of, I think, our evening's discussion, because we're trying to now talk about the programs that we really think will bring us the best access to justice. So going with that same trend, what are we trying to accomplish with our proposal for limited licensing?
This is Alicia. I can take that one. So I think from the very beginning, the goal here is to make legal services more affordable so that people can have access to them. So that's a primary reason that we are supporting limited licensing. It's a one-to-one model that we want to use, but this lower cost would make it so that people who can't afford to pay something, but maybe not pay for a $10,000 retainer would still be able to get the help that they need. Just like, for example, Kernodle was talking about the nurse practitioner. I know when I get sick, a lot of times if it's not urgent, if I don't have a bone hanging off or anything, I can go to urgent care. And most of the time I'm seeing a nurse practitioner or a physician assistant, and I'm paying less money because of that. If something gets really bad, then they'll say, you know what, we can't help you here. Let us send you to the emergency room where they're going to really charge you for, that help that we're going to give you. But at least, I'm having my issues triaged and dealt with and all of that. So that is a primary goal of limited licensing. But that's not where it stops. We want to also relieve the courts of the burdens that they're dealing with. So, this is going to help judges and litigants and the court staff, because when pro se litigants go in on civil matters, they don't know what they're doing. They're going to, not be filing things that they need to file. They're going to be not serving documents that they need to serve. They're not going to understand the local rules. And the judges still have to largely follow these rules. So there's going to be a lot of dismissals and continuances and do-overs when people don't know what they're doing with their cases. So this is also something that we can use to reduce bottlenecks and inefficiencies in the court system. And I think that's why judges generally tend to be supportive of things like limited licensing, because they see on a day-to-day kind of the impact of having people come into their courtroom and representing themselves, and how many people they probably have to turn away and say, I'm not going to be able to hear this case today because something wasn't served, or this isn't the right document, or whatever you've given me is not intelligible enough for me to understand what it is you're trying to accomplish here. Another issue or goal of this limited licensing is to reduce the burden on taxpayers. So when people do not get the services that they need, for example, if we were talking about an eviction and someone were wrongfully evicted from their home because they couldn't afford legal counsel to defend them, and that legal counsel probably would have mitigated that circumstance, then those people have to go into the community or into the government assistance program to get housing. And so you're going to see that in lots of different areas. So, you know, whatever money we can save by having their issues dealt with appropriately in the courtroom is money that taxpayers save on trying to help people get back on their feet later. And then finally, Rachel talks a lot about, she's kind of the expert on pro bono, so I just feel like I need to bring her in on this one. But we also could expand our pro bono pool, right? So in North Carolina, we have somewhere around 4,000 certified, North Carolina certified paralegals. But not just that, we also have a large number of people who have their Juris Doctor, but for whatever reason haven't passed the state bar. And I think the last time we contacted the Board of Law Examiners, in the last 8 or 9 years, I think there's been about, I want to say 7,000 or 8,000 people who haven't been able to pass the bar. So just having that, you know, 10, 11,000 additional people who could potentially be in the legal market on a limited basis could also be supporting pro bono efforts. I think that, you know, being in the paralegal division, we see that the paralegal division puts forth a lot of ideas to try and help with access to justice, but we can't really do anything on our own. In order to be able to offer pro bono services, we have to have an attorney supervise us. So every time we do something, we have to reach out to the attorney population to ask for help. Having a little bit more autonomy would give us the ability to be able to offer pro bono services independently.
Yeah, and I think you hit on like a really good point when, and Kernodle kind of mentioned it with being the like similarity to a nurse practitioner. Obviously, a nurse practitioner will practice up to a certain point, but they also have that intuitiveness that I think would also translate well to doing limited licensing of, I have a client who has come to me, they have a legal problem, I can solve X, but I need help with Y, let me bring in the attorney at that point. And, you know, but it saves on that hourly rate that the attorney would have expended to solve both problems and making it easier. Oh, I'm kind of going into the next question I have, which is, what are the requirements for limited licensing, which would kind of help you to get that idea of, well, why would this individual know what that boundary is?
So I can take that, Yazmeen. So I want to start by saying that these requirements are really just proposed requirements. They are what we contemplated in our original proposal, and I will say that Alicia and Kernodle had largely already drafted these by the time the rest of the collaborators kind of came in, so they definitely kind of get the credit for this. But as far as education goes, we're proposing that paralegals who have a bachelor's degree in paralegal studies or an associate's degree in paralegal studies, or if they have a certificate that they can get if they have a bachelor's degree in paralegal studies, or alternatively, if they have a bachelor's degree plus 15 hours of paralegal studies in foundational courses such as civil, criminal, contracts, investigating techniques, legal research and writing, you know, law office procedures, and ethics and professional responsibility, then they could also qualify. We also have a recommendation that a Juris Doctor, like Alicia just mentioned, someone who has a law degree but has not passed the bar exam, would have a waiver and be able to also do that. And they would not have to go through the certification process that we are recommending for paralegals to have to. So we did say that we would recommend that North Carolina certified paralegals, so those who are certified by the North Carolina State Bar, or the South Carolina State Bar, because South Carolina State Bar the South Carolina paralegal program only requires that they have a national certification. So that would be through NALA, NIFPA, or NALS, I think. So any of those certifications would also qualify. For experience, we say that they should have about 1,500 substantive law-related work within last 3 years of them applying for the license, or experience with it, and experience within the applicable area of law for at least 5 years. And again, Juris Doctors would be exempt from those requirements. Of course, we are recommending that there would be an examination. So in whatever area of law that they contemplate practicing in, they would need to take an examination in that area of law. We don't necessarily have any recommendations right now as to what the requirements of those specific examinations would be. That would be something that would have to be kind of developed, whenever this is approved. But those are the kind of the 4 proposed requirements as of right now.
I'd like to.
Okay, great.
I'd like to piggyback off of Rachel's statement, if that's okay. So we put this proposal together and we submitted it in January 2021. And so, since that time, we have conferred with a number of other stakeholders in this conversation, right? From ILS, the Institute for the Advancement of the American Legal System out of Denver. We've talked to, stakeholders at the state bar, and a lot of other spaces. And so we've learned a lot about barriers and kind of what's needed and trying to kind of avoid some of the things that happened in, for example, in Washington, which, hopefully we'll get the chance to discuss a little bit more later. But we want to make sure that we have a barrier that's appropriate. So we want to make sure that the public is protected. There should be some obvious, education and certification experience and examination requirements, but we don't want to set the barrier so high that we're not actually helping the people we sought out to help. Okay. And so to that end, ILS, the Institute for the Advancement of the American Legal System, they're actually working on a national model proposal. And we hope to be able to glean from a convening that they're having in November, kind of what they might suggest, what all these kind of great minds will come together and make a decision about what a national model maybe should look like that its states could adopt if they chose to go this route. So our proposal could change. It is a work in progress. But for now, when we discuss what we are suggesting, this is what we're suggesting. So thank you for that, Rachel.
Yes, thank you both for that. And so when you talked about kind of what it is that you're proposing that paralegals can do and kind of what the background they should have is, I think another thing that we should touch on is what areas of practice do you believe would best be covered under the limited licensing proposal and why these particular areas would be where it's limited to?
Okay, well, the areas, this is Shawana, the areas or the proposed practice areas that are mentioned in the proposal are family law, debtor-creditor issues, expungements, estate planning, and admin law. And the reason these areas have been proposed is because, like we mentioned earlier, we have seen in the reports and from other studies that these are the areas of law that have the greatest civil legal need, as well as just us being paralegals, being out here on the ground, seeing what people are going through on a day-to-day basis and seeing what we don't have available here in this state or as a nation. And so that's the reason why we've limited it to those areas. We're trying to help as much as we can close in that gap practically.
Perfect. And I'm going to ask Judge Dietz here if he would please chime in as to, as being a judge and obviously formerly working as an attorney, what areas of practice do you believe would be best suitable for limited licensing for paralegals?
Yeah, I mean, I don't have much to add because I think your proposals, so I think there's 2 wonderful things about the practice areas that you've identified. One is there's almost complete overlap with the civil civil legal needs assessments, identification of what areas in particular do people need legal help. And so, this covers a huge amount of that. And, although that was aimed at low-income families, I think it's fair that you can extrapolate from that the sorts of middle-income families that also cannot afford a lawyer but need legal help in these areas, this is the sorts of areas where they need it. I also think these are areas that there's some aspects of these practice areas that are programmatic. And so they're ideal for this sort of proposal because you can, just like how a nurse practitioner or a physician's assistant is trained to be able to say, when I got into this, I thought it was something where I can help the patient, but I'm now seeing the warning signs that this is more sophisticated. And you can get a medical doctor, you can get the physician involved as well. These are areas where there's a lot that a legal technician like what you've described can assist, but also where it will be, I think, pretty readily apparent when you need to escalate and say, I think you need a licensed attorney to assist you. And I think that's why these practice areas will be so, particularly starting out with a model like this, because to me, I think you can provide the legal help here without some of the risks that I think we'll talk about later, which is this concern of what's happening if you don't have a lawyer involved with, but you're providing legal advice.
Thank you, Judge Dietz. And would it be fair of me to say that being that you're here on the podcast and you're interacting with us and you've talked with JFAP before, that you are supportive of the proposal?
Oh, absolutely. That's why I've been so excited to work with these folks. I think this is a wonderful idea. I'm trying to help as much as I can.
I was 99% with it, but you always want to ask because it flows into my next statement, which is, and the next slide, which talks about the benefits to attorneys, because we know that some attorneys don't support the measure. Obviously, you are our grand exception that we are so happy to have you here and promoting this great endeavor. But some attorneys just do not support the concept of limited licensing. So we want to talk a little bit about what those benefits are to attorneys to kind of enlighten them as to, hey, this is a benefit that you should be aware of. So if someone could give me some little light on that.
Sure, this is Morag. So much in the same way as the nurse practitioner, doctor example we've been using, an attorney and an LLC would benefit by being able to collaborate with each other. The attorney would benefit by getting referrals from the LLC. That increases their market share, which is nice. By using an LLC, an attorney is then free to take on cases that are more difficult, more time consuming, put their lawyer skills to the test. But they also know that they can give some of the much needed, but not quite so knowledge intensive or lawyerly intensive cases to someone who can appropriately handle them. They can, if they were to employ an LLC, that's even better, because in much the same way as we're already being used as paralegals by our attorneys to draft things under the supervision of our attorneys, the LLTs have the ability to do more of the attorney-specific things than paralegals do. So that increases their market share as well.
That's great. And I think one of the things that kind of comes to mind after we had talked about it before was that idea of the desert landscape for attorneys. Imagine a solo practitioner or, single attorney firm, and they have a paralegal who is an LLP. Think of how many more people they could help in a county where there's only so many attorneys. I think that's a great way to add into that as well.
Exactly.
So
One of the really cool things is about traveling nurses is they can go into the more rural areas. LLLTs could do the exact same thing.
that is perfect. Thank you. So we've talked about all of these great benefits that we believe that LLPs can provide to the legal community, but I really would like for Judge Dietz, who has obviously been a part of the legal community for so long and is a judge, to kind of give us some ideas as to what he believes would be the benefits for LLPs coming in. I know we've talked about you obviously supporting it, but I think especially for viewers and listeners who are going to come in, they'd love to hear a judge's perspective as to what an LLP can bring to the table that we haven't already discussed.
Sure. Yeah, so you've got a list of 3 different sort of constituent groups here. And I think the first one, prospective clients, is the easy one. So, the barrier to entry into the legal profession is too high. It's 3 years of graduate education and a complicated licensing exam. And the result of that is the price that lawyers must charge for the services is very high. So I think the obvious benefit to the clients is these are people who are making a tough choice of representing themselves because that is the rational decision when the alternative is to pay too much money for a lawyer and to have to make very real sacrifices in other areas of their lives. And so offering that lower cost alternative means that you get an advocate to help you navigate the legal system. And so the benefits to the community, I see this all the time because I travel around and talk to people about what they think about the court system. In fact, I have, because I'm a statewide elected official, I have a license plate. It's kind of odd looking. It's like members of the General Assembly. It has the state seal on it. And underneath that, it says Court of Appeals. And then it has my number and seniority. So it's just a number 3 right now. So it's a weird looking plate. And so people stop me like at the grocery store parking lot or at a gas station and say, are you some kind of judge? What's Court of Appeals mean? And I get to tell them yes and talk to them about that. And the one thing I hear over and over when people talk about their experience with the court system is that it was a bad one because, and I think a lot of that is because they didn't have that advocate, they didn't have help, and they had a bad experience. And I think that word spreads in the community. It hurts the integrity of our justice system when people over and over again have a bad experience. And so I think offering this alternative to people so to make them have a better experience is going to help the integrity of the justice system. And I think for the courts, it's a difficult situation for us when people represent themselves because someone with training is going to do a better job. And that not only eases some of the burden on the court system, it's in particular for my colleagues in the trial division. So the trial judges that in many of these proceedings, like family law proceedings, it can be very challenging. A lot of their energy has to go into trying without crossing the lines where judges have to be impartial to help pro se litigant, means someone who doesn't have a lawyer, understand what they need to do and help them navigate the process. And so it makes the job of the justice system and the people who work there easier to know that there's someone that's providing that advice to these potential clients. So I just think collectively being able, if we can make the system work like this, it's just a win for every part of the justice system, from the people that are going there because they have legal needs, all the way through to the judges and other court staff who keep the system running.
That's great. Thank you so much for that valuable insight. So we have talked at this point about what our program is, what JFAP is. We've talked about what limited licensing program is and what we would like for it to be here in the state of North Carolina. So now what I would like to talk about is what licensing programs already exist, because obviously we've gotten the idea, or it came to us from somewhere. So I would like if someone would be willing to talk about what the other licensing programs are in the United States.
This is Alicia. I can take that one. So when Kernodle and I were discussing putting together a proposal, we, at the time, there was Arizona was about to launch theirs, Utah was in play, and Washington State had a program since 2012 or 2013, and they were beginning to sunset it. Since that time, we have seen programs populate in Minnesota. New Hampshire just passed theirs, and they hope to begin their program in January 2023. Oregon passed theirs. They're going to begin in July 2023. And one that we're talking about the United States, but one that's been in play for a very long time, 15, almost 20 years, is Ontario. They have licensed paralegals in Ontario. So those are kind of the ones that have inspired us kind of along the way, from the beginning and along the way.
And you mentioned Washington State. Can you elaborate a little bit on their sunsetting?
Sure, I can talk about that. So on paper, it looked like Washington's program sunset because there weren't very many people who were taking advantage of the program. So they had 40 or so what they call limited license technicians, and you're going to find a different title for it in every state. But they had about 40 of them, and the thought was that it wasn't financially viable to continue the program because they didn't feel like there were enough people to make a difference. But once we kind of reached out to some of the stakeholders that were in Washington, we many members of our group sit on this national roundtable where a lot of these states and their representatives get together and talk about limited licensing and other types of regulatory reform. And one of the things that we were told by Christy Carpenter and a few other people is that really the issue began in 2018. So when they launched the program, I think that they were doing family law, 2013. There wasn't a lot of communication, I think, perhaps with the Washington lawyers. So it kind of came as a surprise to them, even though there was the public comment period and all of that. There just wasn't a lot of communication there. So there was some consternation about the whole thing. And then when they tried to expand the program to additional practice areas in 2018, then came this kind of outcry from the lawyer population in Washington, who really kind of rallied support to try and put that program down. Okay, so then the former Justice Barbara Madsen, who had been instrumental in putting that program together in Washington, when that Washington State Supreme Court decided to sunset the program, she wrote a pretty powerful dissent on how they just kind of did this summarily without actually reaching out to any of the public stakeholders who had been helped by the program. Right now, like I said, their program's sunsetting, but the limited license technicians that are presently licensed will keep their license. It's just that they're not adding any more licensees. So the interesting thing to me about that is they're still going to have to run this program until these limited licensees start to age out or retire, things like that.
And I noticed on the slide that there is an asterisk next to California. Can you elaborate on that one?
Yes, I can. So California had two working groups. They were working on a regulatory sandbox, and they were working on limited licensing. And this is something that had been going on for a couple of years. They went into public comment. I think it was maybe the end of last year or the beginning of this year. But at any rate, they had an assembly member, Mark Stone, who's a lawyer, and a Senator Tom Umberg, who's also a lawyer. They wrote a letter to the legislature and basically saying that because of disciplinary issues that the state bar was experiencing with their attorney population, they thought that they should focus more on those discipline issues. So in the background, what was going on was California decided to re-fingerprint their lawyers, okay? And when they required that, it came back that there was a large percentage of lawyers who had maybe had some convictions and they didn't report them. And then there were some other rather notable, I guess, misbehaviors by lawyers that were happening in California. And so these legislators were basically saying, we're not really ready to give you anything else to manage because we want you to kind of clean up this mess that has already been made, right? So we want you to deal with the attorneys that are already kind of having these discipline issues before we put you over something else. Now, that's what it kind of looked like public facing, but behind the scenes, when you talk to people like Leah Wilson of the California State Bar, or you talk to people like Natalie Knowlton of ISLES, they're going to tell you that this was kind of a carefully orchestrated plan to kill limited licensing and the regulatory sandbox under the guise of trying to protect the public. So that's kind of what's going on in California.
Gotcha. I appreciate the elaboration. Yeah, sounds kind of like a, oh yeah, this is why we did it. Wink, wink, nudge, nudge.
Right. And so now there's a bill, right? There's a bill. One of the things I didn't clarify is there was a bill that these legislators put together, and it was an appropriations bill that basically said that the state bar can't use funding to run these programs any further. And so that bill, if it hasn't already been signed by Governor Newsom, it's on his desk waiting to be signed.
Got it. Okay, so we have talked about where licensing programs are across the country, but I would like to now kind of talk about what other types of regulatory reform exist across the country.
This is Rachel. I can take that, Yazmeen. So I love this map here because I've heard of a lot of attorneys who maybe don't really have a whole lot of idea about what's going on with regulatory reform, who say, oh yeah, that's never going to stick, that's never going to happen, it's just going to kind of fizzle out. And I love that we can show how much, you know, all the states across the nation are really starting to get into this and are really starting to look at building their own programs. I remember when the first time I ever heard about limited licensing was actually my first semester in my paralegal program, and it was actually my paralegal program director, who was a professor, who mentioned it. And she was talking about, you know, Washington's program. At that time, I don't think that they had started sunsetting. And she was just so excited about it. And so I think I kind of had these like rose-colored glasses that it was something that everybody was going to be excited about. But as far as like other types of regulatory reform, Alicia has already mentioned the states that have limited licensing programs. And we can also see that there are 9 additional states that are starting to consider limited licensing. So that's, you know, 14 states that are already looking into this. New York is actually considering limited licensing of social workers. So that's a little bit different than what we're seeing as far as limited licensing of paralegals. And then there is an injunction in place currently in the state of New York that relates to a bankruptcy app that's kind of like TurboTax for bankruptcy. That is a program that was created by Rohan Pavlori, and his so basically what he did was he wanted to be able to do this app, and he wanted to be able to help people, but using trained professionals who were not attorneys, but basically were able to advise people on who were dealing with collections agencies and that kind of thing to help them figure out how to file bankruptcy, because it's very expensive to file for bankruptcy. And I know that you know that because you're a bankruptcy paralegal, Yazmeen. So anyway, so what he did is, instead of having to wait for trying to go and do this and be sued by the state and all of that and go through all that court process and run the risk of having an injunction placed against his company, he went ahead and sued the state of New York over their UPL laws, so their unauthorized practice of law laws. And he actually got a decision in favor of him in the U.S. District Court in May. Now, the state of New York has since appealed that, but there is an injunction in place. And he did cite Reed v. Gilbert and said that it was based, as narrowly applied in this case, that it was based on the content of their speech. So right now, again, New York has appealed it. It is, pending right now. So we don't know what the outcome is going to be. But as narrowly applied in that case, it could indicate that the practice of law is potentially covered under the First Amendment. So we'll just have to see kind of where that goes. But that's something kind of interesting to know. So Utah does have a legal regulatory sandbox, as well as Arizona has an alternative business structure program. And there's plenty of other states that you can see on here in orange that have other types of regulatory sandboxes. So they're not a legal sandbox, but like North Carolina does have a fintech, which is a financial sandbox. And the thought is that if the legislature kind of has that appetite for that type of regulatory reform, that it could be something they would consider for the legal field in the future as well. So that's why we feel like that's relevant to point out here.
Great, thank you so much for that. So we've talked about, you know, what the programs are that are out there across the state, and obviously we've talked about what we'd like to be here in North Carolina. So my next question is, what kind of regulatory reform is JFAP planning to support, and what is support for limited licensing and other types of regulatory reform going to come from?
So I'll take that one. So we support limited licensing, of course, the regulatory sandbox, court navigator, and any other regulatory reform that will benefit the citizens of our state. Anything that's going to be innovative to get people the legal services that they need. As far as where that support comes from, and for limited licensing, right now, it comes from everywhere except the great state of North Carolina. We have support, as both Rachel and Mercer mentioned earlier, from IOLS. They are, I would say, the leading innovative program that we see right now, because they're looking to stretch it out nationally to see what that looks like. And when you want to create a blanket to cover legal services across the board in that way, that definitely says you mean to have everyone covered and their needs met in a way that no one else has done to date. Jim Salmon is definitely our guy. Mercer's already spoken about what happened in California, so I'm not going to repeat everything that she said, but pretty much they said, we're not going to fund it, we're going to stop it right here. And Lucy Ricca wrote an article about how she felt about California. And if you haven't read it, take a moment and read that article. But what you see here is the highlights of what Jim Sandman's response was to what California had done. And he said that the public favors with the legislator shut down, which is they would love to have access to legal services across the board. They would love to see what we consider to be regulatory reform. And the legislator said no. And he was very clear, lawyers killed it. And they did do it under the guise of saying that they were protecting the public based on no evidence at all. Because really, no one has produced anything that says having alternative legal services or having these different forms of regulatory reform will create any type of public harm. It's suggested, but nothing's been proven. And I think that that's important for us all to talk about. But California has been one of the most aggressive states that have come out and said, we're not having it, and this is how we're going to stop it. And because they've done it that way, it has prepared other states that were implementing or even suggesting having limited licensing. We also have to consider that he identified the current regulatory system being a part of what's causing public harm, right? So nobody's talking about that. We know that our justice system is not perfect. No one has ever said that it was, but to say that doing something else will be harmful and not identifying that what we currently have in place is harmful is definitely a point that had not been discussed prior to this event in California. And he said every unmet legal need, right, civil legal need to be exact, at the national, state, and local levels reach the same conclusion. that the people are not having their needs met. So I think when we talk about what does this look like moving forward, we have to have the conversations with the Judge Dietz, with the North Carolina State Bar and other stakeholders along the way. I often don't talk about the time I spent at the Attorney General's office, but I spent quite a bit of time at the North Carolina Attorney General's office in the Consumer Protection Division. And for some reason, the state, all the residents are under the impression that the Attorney General's office will solve all your problems if legal aid cannot, if other agencies and offices cannot. They can't, they don't. It takes several layers and several tiers to be met before the Attorney General's office in the Consumer Protection Division will even look at most of the consumer complaints being litigated. And it's not discussed. Most of the cases we had was started as complaints that either we mediated at a high level of mediation or we tried to settle before it did anything else. And there were thousands of cases that pretty much if the issue or the concern of the complaint couldn't be resolved, the people were just told, go to small claims court. So if they send you back out and say, go to small claims court, what do you have? Now you have the person who needed legal services, who needed guidance, who needed something bigger than themselves, put back out to figure it out. This is why it's important that we have regulatory reform and that we bring limited licensure or something that looks like it to our state, because offices, agencies, community-based programs, they're not going to be able to do it. And sometimes the structures that we think are serving their needs, they're not. And they covered everything from housing, landlord-tenant issues, resolved and unresolved. We had more unresolved landlord-tenant issues, I think, than legal aid. Sad but true. They had issues with utilities. If you don't understand utility formation, and if you live in a rural community that we don't cover you or the utility commission doesn't cover you the same way in a smaller community that it does in the cities, you're at an extreme disadvantage and you're pretty much at the mercy of the municipality or whoever's in charge in those areas. So those are things that we know as JFAP, because we are researching it, we're pushing it out, and we know those things need to change.
And obviously support for JFAP and LLP is a big thing. So Judge Dietz, going to you, what would you say, or what groups would you say would be your kind of polar opposite in terms of, whereas you are supportive, who is opposing limited licensing and other types of regulatory reform? And why? What's their driving factor to that?
Yeah, so I don't, well, first of all, I don't think anyone will publicly oppose an idea like this. Part of it is because with the data we have, you can't dispute that there are people, there are unmet legal needs. There are people that can't afford the price that's currently charged for legal services, and so they're not going to get those legal services. And so an idea to fix that is one that we should explore. I think there will be opposition, much like you saw in California. The opposition will come from lawyers, and I think there's a couple of reasons for that. But I think it's something that through education and collaboration, it won't be a barrier to moving forward with a project like this, and at least exploring whether it's something that can work for our state. So I think the most obvious reason that some lawyers will oppose it is that the state bar is run by lawyers. We're a self-regulated profession, and the state bar counselors, that the leadership of the state bar are largely accountable to the legal community, to lawyers. And I think there are some lawyers who worry that expanding the number of people that can engage in what's viewed as the practice of law will hurt their business. So part of it is financial protectionism, but I also think that there's an emotional component to this, because it is difficult to become a lawyer. Like I said, you need a graduate education, and you need the bar exam, and this infamously difficult licensing examination. You have to pass that in order to become a licensed attorney. And I think to look at some of the things that lawyers do and suggest that there are people that are just as competent to do that same work that don't need a law degree and a law license can be hard to say, to sort of admit to ourselves as lawyers. And so I think there's a little bit of an emotional aspect to that as well. And I think those are things that can be addressed with education and with data. I think the most important thing we need to have is the people that say, you have to be a lawyer to do this, X, Y, Z. I often say, well, prove it. Show me some data that can reassure me of that, because you just telling me that doesn't persuade me. And I think that's what we need to insist, is that we really want to explore this, and to do that, we need to be able to experiment and collect data and be able to assess, whether or not we're right about that.
And going a little further as we kind of shift into our next topic, obviously people love saying, show me the data, show me the money. And I think one of the things now, as we are going to shift our topic to talking about regulatory sandboxes, if you could explain to us, Judge Dietz, what that is, and we can kind of expound further on what those benefits might be.
Sure. So, when we talk about regulatory sandboxes, you'll most often hear this discussed in areas like fintech. So the regulatory sandbox proposals that here in North Carolina that we're examining and through the state bar and other places are dealing with those sorts of areas. And I think so. If you think about it, it makes a lot of sense there, because these are businesses, in these complicated and sort of novel financial transactions where existing regulatory, so the law as it is now would not permit something, but there's an idea that if we can experiment and sort of test another way to do it in a controlled environment, we can see whether or not it might work. And and I think I've sat in on a number of the regulatory sandbox discussions that have gone on here in our state, and I think it's a great, and I may be getting ahead of you all here. We're talking about this, but I think the regulatory sandbox there's some value here, some potential to use to try to launch a legal technician or limited licensing experiment. I do have some concerns about a sandbox approach here. And the reason is, when you have a novel fintech idea and you want to launch it in the sandbox, you have, in most cases, you have some business that's willing to invest capital, because if it works, they are going to profit from this. And so they're willing to put in a lot of capital and experiment. With the limited licensing, you're asking people, if you're limiting it to the sandbox and it could go away after it's over, you're asking them to invest their own personal resources, a lot of them in the sorts of certification, education, and training that you all talked about earlier, with no guarantee that there's any long-term value to that, any permanency. And that does concern me. So I think whatever sandbox approach we need to settle on needs to provide some assurance to the people who are participating that they get a long-term value out of their effort. Or I'm concerned that we'll have the problem that you heard described in Washington State, where I think what happened there was the barriers of entry were set so high that people thought, well, if I'm going to have to go through all this work to become a legal technician, why don't I just go to law school? Because at this point, it's starting to be the same amount of, the same cost and the same amount of time. And so what I think is we need to harness the fact that we have so many people like the folks here and so many other, very talented certified paralegals, people who have a law degree but have not passed the bar exam, others in these areas that already have a lot of training and experience, and we can supplement that with some form of examination, straightforward regulatory examination, and then say, here's the limited areas where you're allowed to engage in the practice of law, if that makes sense.
Yeah, I think that makes great sense. And so, talking about that program, and can you elaborate a little more on how you believe it would benefit North Carolina as a whole? Like, if it were in its best form, how would it be best for our North Carolina residents?
Yeah, I think, for me, the key to just getting the program launched, and if the sandbox approach is how we do that, the benefit there is I want to see the data. So that's the first thing is we can, because I'm confident that the legal technicians are going to succeed. And so the data will show that there are a lot of things where they can provide legal services to people that otherwise wouldn't get them. And that's going to be very valuable in trying to persuade people to expand the program and make it more of a commonplace thing throughout our state. And I also think that launching a program like this allows the story to be turned into a narrative to help people understand. So I think the media would be very interested in reporting on this because, as I said earlier, so many people in our state struggle and are unhappy with the legal system, the court system, because they can't get legal help. And so hearing a story like this would be very interesting to them, but you need to put a face to the idea. And so having the Sandbox, to me, one of the valuable things that will come out of the program is you'll have not just the legal technicians who are in the program, but you'll have their clients who can tell a story about, I needed help and I got it and I'm so grateful. And I think that can be part of the messaging for expanding the program and even getting some resources from the state and things like that. I should add, of course, the other value of the Sandbox is that you have a lot of oversight, and that provides another layer of protection. So for the potential criticism that comes from, I think, some lawyers and others that the program can sort of spiral out of control, that the Sandbox is a way to ensure that that's not happening because of its limited nature, you have a great deal of oversight from a regulatory body. Although I also think there needs to be questions about what that regulatory body is. As I've said, I'm not sure the State Bar is the natural agency to oversee legal technicians. It may be that the long-term solution is to split paralegal regulation away from the State Bar and put it and these legal technicians under its own state agency that can be responsible for regulating, the practice of law for these people, and not have it regulated by an agency that's made up solely of lawyers, which is what the State Bar currently is.
And I think that kind of goes back to what Alicia and Kernodle kind of mentioned before with California and their issues. So having a separate third party would probably be in the best benefit for everyone involved. So thank you for that insight. We have talked about now what regulatory sandboxes are. And so now I would like to ask the group what states currently have or operate with a regulatory sandbox today.
All right, Yazmeen, I'll take that. So you can see here that certain states have passed into law their version of the regulatory sandbox. Some are financial and technology, some are related to blockchain, insurance. You see Utah has legal services, agriculture, digital medical technology, energy technology, property technology, and what we would consider just a general sandbox. For the most part, they're all general sandboxes when you allow businesses and companies to participate with relaxed guidelines. So Utah and Mississippi and Tennessee, Utah has it, but Mississippi and Tennessee have bills introduced to implement it. Going beyond it to say anything else, Judge Dietz has covered regulatory sandboxes so well, I'm gonna leave it there.
Great, thank you. I appreciate that. Yes, I think that between you and Judge Dietz, we've definitely got it nailed down what the regulatory sandbox is and can do for us. So I would like to now kind of turn our attention to another program, which is Court Navigators. And so if someone can tell me a little bit more about Court Navigators.
This is Alicia. I can answer that question. So Court Navigators are people who provide general information, so documents, written materials, and one-on-one assistance to eligible and represented litigants in the courthouse. That's the short and sweet part of it. Okay, and going forward more with that, are there any active Court Navigator programs, which seems like there are? There are a number of active Court Navigator programs. I'm going to talk specifically about New York's program because it's the one that people seem to know the best. So In New York, they use volunteers to run this program. And so their volunteers are there as moral support for their litigants. They help them access and complete court forms. They assist them with keeping their paperwork in order. And they also help them access interpreter services. They explain to the litigants or the pro se litigants kind of what to expect in the courtroom and what the roles are of the different people that they see in the courtroom. And they can also sit at counsel's table. They can't represent the clients directly, but if the judge has a question of a factual nature, the court navigator can respond to factual questions on behalf of the pro se litigant. So then in addition to that, they're going to start or have already started using court navigators to reach out to people who are homebound to help them with that legal services delivery, and also to make sure that right now it's only in kind of like the 5 boroughs in New York. So they're going to collect data and that sort of thing to see if they can spread that out throughout the state. Creditor issues and maybe some eviction cases. I think that's right. I think that court navigators would be great, you know, in North Carolina. And so I've got like one more story that I want to talk to you about that really kind of touched me. A couple of years ago, this is right before COVID, I had a member from my church call me and tell me that there was a young lady who was in a domestic violence situation. So as a lot of people know, before a woman or any victim of domestic violence is ready to leave, they take an average of 7 times attempting to leave before they actually make that decision. So she had been in this situation for a number of years. And the church member reached out to me and just wanted to know if I could accompany her down to the magistrate's office to take out a domestic violence restraining order. So I met her actually uptown. She didn't know me from Eve, but we walked into the magistrate's office together. I kind of talked to her about what the process would be. Of course, I couldn't say anything. I was just there for the moral support. She got her 10-day 50B restraining order, which if you're not familiar with that, it's an ex parte order. So it's good for 10 days. And then within those 10 days or about 10 days, you have to go back into court. And then the opposing party has to come in and you kind of argue out whether that domestic violence restraining order should continue for a year or so. So she asked me to go to court with her after she had the 10-day hearing. She was scared to death. Like she didn't really know what to expect. She couldn't afford a lawyer. She did reach out to legal aid. And I think that legal aid does help domestic violence victims regardless of the income cap. That's my understanding. But for some reason, she wasn't able to connect with them. They couldn't help her. So I went to court with her, and that was the first time I'd ever been in domestic violence court. So I walked in and they had the women sitting on the left and the men were sitting on the right. And so I sat next to her on the left. I couldn't obviously talk to her while we were in the courtroom, but when her spouse walked in, the one that had been beating on her, you know, she was shaking. She had her paperwork in her hand, she had a folder, and she just was shaking pretty violently. And I was kind of, you know, just telling her it's going to be okay and just trying to calm her down. Well, when the judge called her up for her case, she stood up and she, you know, walked to that center aisle so she could walk to the front of the courtroom. And her hands were shaking so bad that she dropped everything. Like all her paperwork and her pictures were all over the place. I instinctively stood up to try and help her because, you know, you're not thinking, and the judge told me to have a seat, right? So I couldn't do anything. She picked up her papers by herself and there were just tears just streaming from her face. And I felt like just really awful for her. So she went to the front of the courtroom, and it really was, it was bad. You know, she was sitting next to this man that had, you know, basically held her overnight and had beaten her for hours. And now she had to sit at this counsel's table by herself and question him as he sat on the witness stand and try to keep her composure. I couldn't sit next to her. She couldn't have anybody else at the table with her. So she was all on her own. And let me tell you, she stumbled over her words. She didn't know what questions to ask. She didn't know how to examine or cross-examine. She didn't know how to introduce evidence, and he had an attorney. So everything she said drew an objection, okay? And it was a very difficult process to try and get through. What the judge ended up doing in that particular case was the judge kind of split the baby, so to speak, and gave her a 6-month restraining order because she was convinced that some domestic violence had occurred, but she couldn't put the case on well enough for herself in order to be able to get a year, okay? So that was, to me, one of the things that said, you know, that's something that someone who had a limited license could take care of, but also absent a limited license, having a court navigator, someone that can be in that courtroom as a moral support to sit with her, probably would have made some difference when the judge was asking questions of her, when she was like shaking and she couldn't get her words together, to have someone that knew the facts of that case to be able to answer those factual questions. That probably would have made all the difference. And there are probably a lot of people in that situation in the domestic violence courts and other courts that could benefit from a court navigator program.
I think that, first of all, that story is very powerful. I think that a lot of people don't consider, I'm drawn back again to kind of the medical connection of, if you imagine when you're going to the emergency room because you've been injured and the emergency room doesn't tell you, oh, you can't have so-and-so with you. You can kind of decide you have that person who's that moral support. Obviously, they can't answer for you as to your medical information, but they're still there when you're obviously very shaken and upset. And the idea of having a court navigator who is just there, even if it's just as a hand to like squeeze when you're really shaking, and you just know that person is there to help you, I think would be such a powerful tool. So I appreciate that insight. Again, very powerful story. So we've talked about New York specifically, but now I'd like to ask what other jurisdictions have court navigator programs across the country.
Sure, this is Rachel, and I can take that one. So you can see here there's a list of localized court navigator programs as of June 2019. So these are not statewide programs. They either exist within a certain district or county, but those are states that do have them. We have recently learned that Interact of Wake County, which is a nonprofit organization that helps domestic violence victims, has partnered with North Carolina State University for a court navigator program. So basically they are able to help Interact clients in those kind of domestic violence situations like Alicia was just talking about. But unfortunately, that's not a statewide thing. It's just something that exists for that one nonprofit, and they were able to partner with the university to do that. So there is the Justice Lab at Georgetown Law Center had a report that showed kind of like what the effectiveness of some of these court navigator programs were. So the Illinois Justice Corps survey on the effectiveness of court navigator programs showed that 90% believe that navigators improve the completeness and the correctness of documents filed by SRLs. And 82% felt that SRLs were better prepared for the court proceedings. And then over 70% felt that navigator assistance actually saves time for the court clerk who is trying to walk people through the forms that they need and that kind of thing. And then there was another survey by California Justice Corps that showed that on a 4-point scale, 92% of the paperwork assisted by the Justice Corps members rated at the top of the scale for being most completely accurate. And those, by contrast, who had received no help were rated significantly lower with an average score of 2.3. So that's just something you can go to that report and see some of the other feedback on that. But I thought that was really interesting to see what kind of difference these programs are making, even though they are just localized programs.
Thank you. I appreciate that. All right, continuing the discussion of all of these initiatives that we've discussed today, limited licensing, regulatory sandbox, court navigators, what is the current status of all of these initiatives?
are you meaning in North Carolina, Yazmeen?
Yes, in North Carolina.
Okay, I can take that question. So the limited licensing and the regulatory sandbox and the court navigators, they were all discussed. The state bar created a regulatory change subcommittee, and there were recommendations that came out of the subcommittee that the greater state bar are hopefully still considering. But the limited licensing is, we're still trying to kind of build support and a coalition to hopefully approach the General Assembly at some point and move that forward. With regards to the court navigators, I believe the state bar made that recommendation to the AOC, the Administrative Office of the Courts, to see if that's something that they wanted to implement. So that, since from my understanding, that's not something that has to go through the legislature. And the regulatory sandbox and limited licensing, like I said, the state bar has just created a standing access to justice committee. And I think that both of those topics are going to be discussed probably in the new committee. So none of these, not limited licensing, regulatory sandbox, or court navigators, have a specific plan to get them implemented at this point. It's just everything's kind of in discussion. There are a lot of stakeholders having conversations about what they believe is a viable path forward.
Great. And in terms of talking about a path forward, Judge Dietz, what has to change legally to accommodate regulatory reform in North Carolina?
I think the big thing is there's there's a statute that governs the unauthorized practice of law. A lot of what we've talked about here bumps up into that statute because this has traditionally been interpreted pretty strictly. And so that, one thing is looking for ways to maybe loosen that longstanding restriction. And then I think the other barrier is going to be just needing to educate the public and educating the bar so we can sort of get this message out, and the Justice for All project can kind of grow its network of supporters and stakeholders that want to get involved. And I think there are a lot of lawyers that will think this is a wonderful idea, and I think the public, when they understand it, we strongly supportive. What I've told the folks at the Justice for All project is I view this in some ways like some of the other innovations that have really caught fire, like even things as simple as ride sharing apps, which if you had told me 10 years ago that things like Uber and Lyft would be ubiquitous, not just in here in North Carolina, but in places like New York City, where the taxi industry was so heavily regulated and so politically powerful, I would have said you're crazy. That even if it's a good idea, it could never happen. And of course, now I can't imagine not using a ride sharing app when I'm going around. And I think that something like that could be coming for the legal system because of all its challenges. And I certainly think that lawyers would rather have it be something where they have some control, and it's the option is something like legal technicians, than to be completely disrupted by somebody in Silicon Valley that comes up with a way to solve this problem with access to justice that without consulting lawyers at all. And so I think there's a lot of reasons that everyone will want to be involved in this project, and it's just a matter of helping people understand the need and that this solution can work.
Great. Thank you so much for that. So we've talked about what needs to change, what we currently have. I'd like to now kind of talk about and this is to all of our Justice for All folks, what types of regulatory reform do you think is most important for our state of North Carolina?
This is Shawana. I will speak to that. JFAP, as we've mentioned before, supports any type of reform that is going to provide a bridge to the access to justice gap. We are in support of the court navigators, regulatory reform, and all of those things are just a small piece of a puzzle or a plank in the bridge that can help North Carolinians. Paralegals and law school students and JDs, like we've mentioned before, have the greatest ability to directly assist with this access to justice gap because of the training and the experience that we have. If the North Carolina General Assembly will pass legislation for the limited licensure. One's no more important than the next. It's all part of the greater, or the piece to the puzzle to solve and have a solution or be a solution.
Great, thank you. So now to kind of wrap up our discussion for the day, one of the things that I'm sure as everyone has been listening today and learning more about the Justice for All program and what their initiatives are, you may be thinking, well, what can I do to contribute? What can I do to be a part of this great initiative that's out there? And for that, I'm going to ask JFAP, how can people come in and support you?
Well, I can answer that. We have several different project committees that we are definitely looking for volunteers to help out with. That'd be the administrative committee, the public and outreach communications, the legal community outreach, legislative drafting, national research, and our social media committees. So if anybody's liked what they've heard about what our project is and want to get involved, we definitely encourage them to check out our website and sign up for one of our project committees.
Great, thank you so much, Morag. And as for everyone who is listening, or if you're seeing this on YouTube or anywhere that the video will be posted, there will be links in the description that will show the JFAP website. You'll learn more about JFAP. You can learn more about all of the individuals who have spoken today, and you can figure out how to get more involved. So we really encourage you to check out that description and find those links and reach out. So now, after hearing everything that you've heard, and maybe you now, maybe you want to join the efforts, but maybe you also have some feedback you'd like to provide, I will ask JFAP again, how are some ways that our listeners who have tuned in tonight can provide some feedback regarding the proposal?
This is Alicia. So we recently put together a survey, and this might be something that is perhaps more interesting to people who are working in the legal field, but certainly we invite feedback from anyone in the public who wants to give that feedback to us. But in trying to put together another updated version of a proposal, we have a survey that asks, first of all, if you support limited licensing, but also what are the requirements that you think a limited licensee should have. So you can go to this QR code, or you can go to the website and there will be a link below this video and give us that feedback. The survey probably takes 10 minutes or so to complete, so it takes a little bit of time, but the feedback will be very helpful to us and the work that we'll be doing in the future.
Great, and yes, obviously, anytime you can provide feedback, this whole process for our paralegals is to not only help the access to justice, but also to give you, at least in my mind, the idea of a better way that you can help those around you, and what better way than helping to bridge that gap. So any feedback that you can provide, I highly encourage you to go to that survey link. And do we have any last words from Judge Dietz or any of our Justice for All project panelists this evening?
This is Alicia. I just want to say thank you to Judge Dietz for taking the time to talk with us about these issues, and for your support and mentorship. We really appreciate it. And I also thank my JFAP members for taking time out of their evening to have these discussions.
Well, I, for one, want to thank all of you for coming out this evening, for participating in the discussion. Thank you for having me as your facilitator. And thank you to everyone who has tuned in to listen. I know that we've talked about a lot tonight, but I think it is important that we do talk about it because we've mentioned it several times. There's an access to justice gap. We are here and doing our best efforts to try and bridge that gap. And the only way we can do that is with you all being involved as well. We can only do so much, so we want you guys to join the conversation, join the project, get involved. If you have questions, you can see here we've got our website posted here. There's Facebook, LinkedIn, and Twitter. Reach out with any questions. We're happy to answer what we can. Thank you all very much for coming out tonight and for listening, and I hope that you all have a great day.